Insurance adjusters are trained to go on fishing expeditions if they get an unrestricted medical authorization. Essentially, what they do is they take a medical authorization that a person gives to them, and they go into the history of the person to find medical information that might impact the current injuries that the person is suffering, or things that are completely unrelated to the current injuries that a person's suffering. But if they get something from years ago that may relate to an injury that you now have, what they always try to do is say that your problems are really related to the previous injury you had, for example, of your back or your neck. And they try to use that to devalue the claim payment that they're going to offer you. These are just very common practices by insurance adjusters who are able to access all of your medical records. If you're in a situation where you sign an unrestricted medical authorization, the other concern that you should have is those records that are produced could be shared with persons or companies that have no business seeing them. For example, indexing services that insurance companies use to basically do an index of your medical history will sometimes be provided access. And if those records are not meticulously protected, there's no way you know who's seen the records or where they may have been disseminated. So when we handle cases for our clients, what we do is we do not give unrestricted medical authorizations. We restrict those authorizations to the injuries at hand, and we restrict them by time. So we're not going to let somebody go 5, 10, 20 years into our client's past without having the court order that and having a legitimate basis provided to us. Overall, my advice to anybody who's being asked about medical authorizations is protect your medical history and do not allow records to be disseminated on you without knowing exactly how those records are being handled and why they're being handled by an insurance company.